Good evening, ladies and gentlemen. For the benefits of those who have not attended these hearings, procedures as follows. The petition will be heard in order that they were posted in legal notice. However, the chairman may change the order with consent of the board, including the public hearing as appropriate. The board will treat all petitioners and their representatives, abutters, and other interesting parties fairly and with respect. We allow each petitioner to state why his or her petition should be granted. Following the petition statement, any abutters or interesting party is allowed to speak for or against the petition. In interest of getting all the facts, we will go around a second time. The board may elect testimony at any point, but we cannot allow any cross discussion. All questions must be directed to the board. Also, we ask that you do not repeat yourself or your neighbor's testimony. If you wish to just indicate concern, yes, please do so. After hearing all the facts regarding the petition, the chairman will close the public hearing and the board will deliberate and vote on the petition before moving on to the next petition. You can expect fairness and impartiality by this board. The zoning board is empowered to legalize the breaking of the town zoning ordinance, and this is not done lightly. State law and local ordinance set out for the criteria that must be met in order for this board to grant your petition. I remind you that it is your responsibility to prove your case so that this board has justification for granting the petition. The minimum requirements are listed in the format that you received from the Community Development Office, and it would be helpful if you would proceed on that basis. Please turn off all cell phones and pages. Will all people who plan to testify please stand up to be sworn in? Raise your right hand. Do you swear to tell the truth, the whole truth, so help you God? Yes, I do. Thank you.
All right, we're going to start with the first petitioner, which is College Bound Movers, in Benjamin M. Basowski, Jeffrey Clegg, Jessica Clegg, Jacob Mitchell, and Ethan Mitchell, owners. Request for a rehearing regarding case number 2014-40, in which the board voted to deny a variance under section 2.02.1.a of the zoning ordinance to permit a parking for employees, customer vehicles, and temporary mobile storage units located in the I-1 industrial, residential, and aquifer conservation districts and wellhead protection area at 22 Continental Boulevard, tax map 3C, lot 085, case number 2014-47. And
Madam Chairman, because this is a request for rehearing, there is no public testimony on this particular case. In your packet, you should have the request for rehearing from Attorney Greg Michael. And as outlined in the staff memo, the board needs to determine whether or not the decision that was made was either unlawful or unreasonable in order to grant the rehearing.
all right, is there any discussion?
Sure. Yeah, we discuss them ourselves.
Pardon?
We discuss them ourselves, sure.
Right, yeah.
Oh, I thought you were
No, I'm asking the board if they have any discussion.
misunderstood.
Phil?
Well, just to clarify a little bit, because I was the one that thought maybe planning board should take a look at this. But the decision has to be that we did something unlawful or unreasonable, and I don't think we did. I think we, made the best determination we could.
Tony?
If the board considers the appeal and say yes, we will accept the appeal, that doesn't mean that the board automatically says okay. They could still deny the petition, just to make that clear to the people. Thank you.
Yes.
Madam Chairman, just to remind the board, one of the reasons that the petitioner in this case has requested the rehearing, if you recall, at the hearing last month when this was originally denied, the board made the motion to deny based on the lack of meeting the hardship criterion. I specifically asked the board at that point if they wished to clarify and state a specific reason why it didn't meet the hardship criterion at that time, knowing that the potential rehearing request would come. That was not done, so I think the board should consider that as part of your decision-making here tonight.
All right, thank you. Patrick?
I also agree with comments that were actually made by Phil in the meeting in regarding to dictating what somebody can and can't do with their property. And the other thing too is by the sound of it, if ZBA does the rehearing and it does go through, planning board still needs to sit down and look at the final plans of how the land would be laid out and would be able to address any issues. I think that during the meeting, there were things that were discussed that were a little more planning board focused than ZBA focused.
I believe there was supposed to be some changes
And
in the layout.
I think so. I think the planning board would be in better place to address some of those issues and concerns, not only for the movers but for the abutters as well. So, you know, that's my take on after reviewing it and looking back on it.
All right, go around once more. Rich? Phil? Tony? Patrick? Okay, do I hear a motion?
I make a motion to have the rehearing case 2014-40, in which the Board of Vote to deny variance under Section 202(1)(a) of the zoning ordinance to permit parking for employees, customer vehicles, and temporary mobile storage units located in industrial, residential, aquifer conservation district, and wellhead protection area at 22 Continental Boulevard, tax map 3C, lot 085, case 2014-47.
All right, I just want to make it clear, your motion is to grant a rehearing.
Yes.
Do I hear a second?
Second.
All in favor, say aye.
Aye.
All against?
Aye.
4, 1, 0. Oh, okay, your rehearing is granted. All right, thank you. All right, with the permission of the board, I would like to move items number 5, 6, 7, and 8 up next. And item number 4 would be the last one to be heard. Is everyone in agreement?
Yes.
Okay.
Okay, all right, they all agree. So the next item is Donald Turner, petitioner owner. Variance under section 3.05 of the zoning ordinance to permit a 26 by 40 foot garage and workshop within a 23.1 feet of the front property line, whereas 30 feet is required, and within the 15.2 feet of the rear property line, whereas 40 feet is required. The parcel is located at 5 John Lane in the residential and aquifer districts. Tax map 4C, lot 265, case 2014-43. And who will be testifying on for Donald Turner? All right, would you sign in, please?
While the petitioner signs in, just a quick bit of background on this for the board. The lot may look familiar, and the reason for that is back in May, there was a variance granted for the previous property owner of this property to allow the construction of a deck within 17 feet of the rear property line where 40 was required, which was granted by the board back in May.
All right, thank you. And would you make sure the light on your mic is bright green
It is.
All right. And what we're going to do here, we started a new policy. We'd like you to read the 5 points of law first, and then we're going to get into the background, whatever you'd like to testify on. But you have variance questionnaire responses is the title that you have on there.
Yes.
If you go into that, and then we'll hear the changes you want to make or whatever you'd like to testify on.
Okay. The variance questionnaire responses, the variance would not be contrary to public interest because the proposed garage is allowed in a residential neighborhood, and having a garage is common in this neighborhood.
All right, if you hold on just a moment, we're going to stop after every item
Okay.
and see if anyone has any questions. All right, go ahead.
And number 2, the spirit of the ordinance is observed because by granting the variance to allow for a garage to be added to the existing home would be no threat to public health, safety, or welfare. It would be attached to the existing home, making the most sense for the location. There is no location on the property that would comply with current zoning setbacks.
Everyone all set on that? Okay.
And substantial justice would be done because granting the variance adds to the tax base of the property without harming the public, and denying the variance gains no benefit to the public.
All right.
And the values of the surrounding properties would not be diminished because the attached garage should raise the property values and keep the property in the same character as the surrounding properties, as there are many homes in the neighborhood with garages that are non-compliant to the current zoning regulations.
Go ahead.
And little enforcement of the provisions of the ordinance would result in unnecessary hardship. It is impractical to place the garage anywhere else on the property, including over the septic system. It's an old septic system. In addition, the driveway is in the proposed location of the garage, which would allow direct access into the garage. The proposed use is reasonable because the proposed garage workshop will be attached to the house and will lend itself to the overall continuity of the neighborhood.
And go ahead with B.
And B, the size,
Before we go to B, as long as the board is comfortable that he's met parts 1 and 2,
Okay.
B is not necessary if you believe he's met those requirements.
Yeah.
Okay. Does anyone have any questions or comments? And do you have anything further you'd like to add, Mr. Turner?
not at this time.
Madam Chair, I have
Yes,
a question.
go ahead.
about this.
Okay.
Proposed garage workshop, at-home business, or just,
No home business. I've always liked woodworking, tinkering. I've always done my own work on my cars and this sort of stuff. My dad, before we put him in an assisted living, gave me, some table saws and a little drill press and a joiner, and I need a place to put these.
okay. Fair enough, thank you.
Typical man thing.
Yes.
All right, I'm going to open the public hearing. Is there anyone here who would like to testify for this item? Anyone who'd like to testify against it? Close the public hearing. And anything further from the board? Could I have a motion, please?
I'd like to make a motion to grant Donald Turner variance under section 3.05 of the zoning ordinance to permit a 26-foot by 40-foot garage and workshop within 23.1 feet of the front property line, whereas 30 feet is required, and within 15.2 feet of the rear property line, whereas 40 feet is required. The parcel is located at 5 John Lane in the R Residential and Aquifer Conservation Districts, tax map 4C, lot 265, case number 2014-43.
Second.
All right, all in favor, say aye.
Aye.
Anyone against? 500. Thank you, sir. And if you wait 30 days, just in case something comes up, if there neighbor has a problem.
There is
or-
a statutory appeal period that anybody aggrieved by the decision could request that the board rehear the case.
Okay.
You're free to proceed during that time, but you do so knowing that it could be appealed during that 30-day time period.
I best better talk to all my neighbors first, which I already have. Thank you.
All right, the next item is Kathleen and Carlisle Hatfield and Richard and Christine, petitioner owners, requesting a variance under section 3.02 of the zoning ordinance to permit a lot size of less than 10,000 square feet for 2 lots in the residential district located at 11 Autumn Lane and 46 Greenwood Road. Tax map 6A-1, lots 069 and 070. Case number 2014-44. And who would like to testify on this one?
Good evening. Stephen Keach from Keach Nordstrom Associates. With me tonight is Kate Basso, manager of the project, who will be doing a portion of the presentation. You'll notice that on your agenda there are 3 items. They all relate to the same property. So for the purpose of the testimony we give, I think there's going to be some redundancy if we do them separately. So with the board's permission, I'd like to... With the board's permission, I would like...
Is the mic on, Steve?
Yes, it is. With the board's permission, I'd like to provide testimony in the 5 points of law because that relate to all 3 of those items at one time, if that's acceptable.
Yes. All right.
The
what is
board has the option, if you wish to open all 3 cases simultaneously and vote on them, you would need to take a separate vote for each variance
Right.
at that time. But if the board wishes to open the public hearing for all 3 at the same time, you could certainly do so.
Board, what does the board? Yes, yes?
Yes.
Tony? Patrick? All right, go ahead, Steve, all 3.
Before you do that, you want to read into the record the other 2 cases so that
All
people know we're open.
Bear with me, Steve.
You're bearing
All
with
right,
me.
the second associated item is Kathleen and Carl, Richard and Christine Hatfield. Petitioner owners variance under section 3.02 of the zoning ordinance to permit frontage of less than 250 feet for 2 lots in the residential district located at 11 Autumn Lane and 46 Greenwood Road, tax map 6A-1, lots 069 and 070, case number 2014-45. And the last item, Kathleen and Carl and Richard and Christine Hatfield, petitioner owners, variance under section 3.02 of the zoning ordinance to permit a building addition as close as 49.4 feet from the rear property boundary, where 60 feet is required in the residential district located at 46 Greenwood Road. Tax map 6A-1, lot 707, case number 2014-46. Did I get it right?
I think so.
Okay, go ahead, Phil.
Yeah, you got it
Just-
right. I just want to...
Just for the board's...
Just for clarification, I want to say this is case 44, 45, and 46 combined.
Right.
The other thing I'd like to note is the lot numbers that are included in the agenda are the proposed lot numbers, should the lot line adjustment ultimately be approved by the planning board. There are currently, I believe, 3 lots or 4 lots involved.
4.
There are 4 lots involved today, in terms of what
All right, so it
Steve will
didn't
be able to
stipulate
explain
that.
that.
Okay.
Yeah, before I get into the points of law, I think because of this 4 parcels of land that are all contiguous and owned by the Hatfield family, Carl and Kathy and Christine and Ricky. 2 of the properties are principal residential structures that each of the 2 Hatfield families reside in. And basically, this all comes about as a result to repackage these 4 parcels to create 2. I think it would be very useful for the board if Kate, just to give you an overview before I give you the points of law. We were trying to clean up basically 4 pre-existing non-conforming lots. and make them contiguous and as conforming as possible.
Right, short version or
Hmm?
short version?
Yeah. That's why
Okay.
I'm going to have her do it.
All right, go ahead.
All right, thank you. As he said, there's 4 lots involved.
Is your mic on?
No. As he said, there's 4 lots involved. They're on Autumn Lane and Greenwood Lane. Lots 69 and 70 are the 2 larger of the lots, and lots 98 and 99 are partly in Amherst. They are the 2 smaller lots. Carl and Kathy live on lot 69. That's their principal residence. And Christine and Richard live on lot 70. They have, their home is right here, and this is Kathy and Carl's house. So the lot up top with the frontage on Autumn Lane, this lot right here, that was picked up by Christine and Richard so that they could have their septic system, because their lot where their house resides is currently very small. So there's an easement that goes and cuts through Kathy and Carl's lot for their driveway and for their septic system. It's along Babusick Lake Road on the southwest over there, and there's one other existing building right now, and that's to be taken down. It's on the property 98. So we're proposing a lot line adjustment and consolidation from 4 lots into 2. Currently, all 4 lots are non-conforming lots, so we're trying to make it 2 non-conforming lots instead of 4. Lot 70 right now has 169 feet of frontage, so it's already non-conforming, and we will not be changing that. It will still be 169 feet post-development. And then lot 69 currently has 150 feet of frontage, and we're going to keep that the same as well. Those are existing non-conforming and will not be changed for our proposal. And both lots proposed also will be under 100,000 square feet in total area, which is required. Lot 69 will be 71,346 square feet afterwards, and lot 70 will be 92,330 square feet afterwards.
All right, why don't we go into the points of law there?
will.
Are you going to do that,
Yes.
Steve?
Yes, as Kate indicated, basically, we're repackaging the family property to create 2 lots and create those in a contiguous fashion. The only part that was relatively new was the
To the mic,
postage
Steve.
stamp lot that is adjacent to the
Pull the mics
Hatfields.
closer to you.
Yeah. The only, one of the structures, the camp that is on the lake that's next to Ricky and Christine's house, will be torn down. And obviously, one of the items tonight was a variance for a rear yard setback, because they intend to build a garage and mudroom addition to their home after tearing that building down. So, points of law. Granting the variance will not be contrary to the public interest. The proposal, we believe, will have a positive effect on the public by decreasing the number of pre-existing non-conforming lots from 4 to 2, and getting rid of a pre-existing non-conforming residential structure on one of them. So basically, there'll be 2 residences instead of 3 that exist there today. 2 of the pre-existing non-conforming lots will go away. And on the lake, we feel that's in the public interest because of the fact that obviously that little lot that will be consolidated into the Hatfield property has its own septic system and so forth now, and this is getting rid of that potential health hazard and risk immediately on the shores of Babusick Lake.
All right, could you just stick to the 5 points
Yeah.
right now, and then you can go into the detail afterwards, okay? All right,
Well, we
any-
feel that is in the public interest to do all of that. Now, the spirit of the ordinance will be...
Could you hold on, Steve?
Yeah.
We have to stop between each one. Any questions?
I actually do have a question. I'm trying to understand what we were talking about, the easement in regards to the septic system. In this new proposed lot, is the 6A 1-69 holding the septic for 6A 1-70 in the new proposal?
What happens today, Richard and Christine's house lot is here. Their septic system is up, this lot up here. And those, parcels are not.
You're not getting the volume,
Oh.
not getting audio.
No, you need the mic, Steve.
Was it working? Yep. Apparently so. Today, and for the last several years, Rick and Christine's house is on this parcel here. That's lot 99. When they converted that from a seasonal to a year-round residence about 15 years ago, they acquired the lot next to their parents' lot, and the septic system for their dwelling is up on that parcel. Because those parcels are not contiguous, Rich, there was an easement granted over Carl and Kathy's lot so that they could construct a force main to get from here to there. The purpose and intent of that easement will disappear upon the easement will no longer be needed, and it can be extinguished. Part of what we're doing here with the lot line adjustment is creating contiguity. Basically, the three parcels, 99, 98, and 70 are all going to be consolidated into one parcel. And in order to create the contiguity, we're taking a piece of lot 69 so that they're no longer fractured as far as so the driveway and the septic line and the utility lines that serve Richard and Christine's house will all be on their parcel.
Okay, that explains a lot. Thank you.
Madam Chairman, there is a colored drawing of the same version that you have in your packets if you would like to accept those tonight.
Does the board want to accept the
Just to
color?
clarify, this is not new material, it's just a colored version of the same material we have. So I think that in that particular case, then it would make sense because it's not new material.
Okay.
It's just to better show you guys what it looks like.
Absolutely, we do appreciate that.
Everyone got one?
Get one more for Lenny?
Well, that's good English, everyone got one. That's
Yeah,
good.
do you have another one, sir?
Continue.
Yeah, it does make it a little more understandable. Thank you.
The second point is the spirit of the ordinance is we believe it is observed because although lots 69 and 70 do not meet the 100,000 square foot minimum lot area required in the residential zoning district, the existing lots that abut the property are significantly smaller in size and range from 2,613 square feet to 57,063 square feet. In an effort to reduce the overall number of non-conforming lots in the area, the proposal consolidates three lots, 70, 98, and 99, into one 71,346 square foot lot and adjusts the lot line with lot 69 to provide a consolidated lot with frontage along Autumn Lane and allow full access to the existing driveway. The pre-existing non-conforming frontage distances on lots 69 and 70 will remain unaffected by the proposal. Essentially, what we're doing is trying to create two contiguous lots as close to conforming with zoning as we can at the expense of the loss of two. So we feel that is in keeping with the spirit of the ordinance because it takes these pre-existing conditions, makes it conforming to the fullest extent that it can within the aspects of the property.
Patrick? Tony?
No.
Bill?
Nope.
No? All right, go ahead with number 3.
Yeah. We believe that granting the variance will achieve substantial justice because by allowing the reduction in the required lot area, the consolidated property will have an opportunity for the benefits of frontage along Autumn Lane and full access to the driveway. Could go on that, but it will also get rid of this fragmentation that's occurred out there at the present time. It'll achieve a very good outcome for not only the Hatfield family, but for those who are around them.
Questions? All right, go ahead, Steve.
The fourth item is for the following reason, we believe the values of surrounding properties will not be diminished. A reduction in area of lot 69 will not diminish the values of surrounding properties. The overall project scope will decrease the number of lots, which will in turn limit the density of homes in the area. A high-density area can be perceived as less desirable due to smaller yards and close neighbors. Reducing density, property values will be maintained or increased. And I'll add to that, the building that will be raised is not in the greatest of shape and is kind of an eyesore and probably a danger at some point in time. And that will be taken down, the lot that they acquired quite recently. That will be raised to make way for a garage for Ricky and Christine's house. So we believe that, despite the fact that this doesn't contemplate really any new construction other than an attached garage, it's kind of cleaning up the area through the lot consolidation, the raising of a tired former camp structure, and so on and so forth. So probably neutral on the question of property values. It might even help a little bit, but it's certainly not going to diminish.
Questions, comments? Go ahead, number 5, Steve.
Hardship argument. Owing to special conditions of the property that distinguish it from other properties in the area, denial of the variance would result in an unnecessary hardship due to the fact that no fair and substantial relationship exists between the general public purpose of the ordinance provision and the specific application of the property to that provision to this property. Because in the current instance, each of the 4 subject parcels are pre-existing non-conforming in terms of lot area and frontage. Under the current proposal, the applicants seek to eliminate 2 of these parcels for the purpose of creating 2 contiguous lots of a geometry as close to conforming as possible. Obviously, we need this variance in order to do that, or these variances in order to do that. And the proposed use is a reasonable one, in that it allows the Hatfield family to repackage parcels to best fit the land as each of the 2 principal residential structures situated thereon. Basically, they each have a home, and by reconfiguring the property, it's a logical reconfiguration so that each of the physical improvements that support each of the 2 homes are on the property, the same property that they support, instead of having cross easements and driveways or growing across one lot for the benefit of the other, utility lines and so forth, like it is today. It cleans up legacy, and I think a denial of these variances would pose a hardship for somebody who's presumably trying to do the right thing.
Any questions?
Madam Chair?
Yes.
I actually have a question, and it might need Steve to come up to point it out on the 2 maps here, because I just want to get clarification on something.
Go ahead.
Can I ask him just
Sure.
to approach with the portable, please? If you could just step by, I had a quick question. This is the proposed map that the proposal here, and we're talking about those 2 there. What are those 2 there? Because they look like they're also part of that, or is that not something?
This is the town line.
Yeah.
This is the town line here.
Okay.
So that's a Amherst map and lot number. These 2 parcels have lot numbers in each town, but they're one piece of land.
And okay, so you're going to go to Amherst for those 2 then? Okay.
Yeah, all they'll do is, this is, the lot line adjustment portion of it is subject to the provisions of RSA 674-53, land affected by municipal boundaries. So the plat that we're going to seek approval from the Merrimack Planning Board will actually probably be approved by the Amherst Planning Board before Merrimack Planning Board sees it. You're going when?
November 5th.
November 5th.
I just asked because when I looked at the proposal, I saw those 2 extra plots, and I wasn't sure. Obviously, the family owns those 2. Right?
Trying to sneak one in on you, Patrick.
Yeah. I appreciate it.
All right. right, any questions at all from the board?
Again, if the board is satisfied with those, you don't need to get into Part B.
Are you satisfied with the 5 points so far? Tony?
Sure.
Patrick?
Yes, ma'am.
Okay. So do you have anything further to add, Steve?
Probably
Or, I'm
not.
sorry. Sorry, I don't know her name. All right. Then I'll open the, I'll open the public hearing. I want to read something into the record. Okay, I'm opening the public hearing. Is there anyone here who would like to testify for these petitions?
Well, I'd like to say something.
Have you been sworn in, sir?
I guess I missed it.
Raise your right hand. Swear to tell the whole truth.
I own some property right here. Hold on, abutting this property.
Raise your right hand. You swear to tell the truth, the whole truth, so help you God?
I do.
All right, and could you sign the sheet there too, sir?
Sure.
That you've testified? Sir, what is your name?
Vito Ogello. I own property abutting this Hatfield.
Last name is Ogello?
Ogello, A-U-G-E-L-O. I got a letter from Donna.
All right, would you go to the mic, sir, or sit down at the table, one of the two?
Excuse me, sir, are you for or against this?
Well, I just have questions.
Okay, go ahead.
Just questions.
All right, well, I'm doing petitioners for it right now. Okay, go ahead, sir.
Okay, well, actually, if I can just go to the map.
Peter?
It's located right here. It's lot number 95. And my cottage is right across the street on Greenwood Road. And we've been living at that property as a summer resident for over 52 years. So I've seen a lot of changes in the area. But my main concern is the lake, is the quality of the lake, and how this new subdivision is going to affect the quality of the lake. There's wetlands on one of the properties delineated in this section right here at lot number 70. There was a stream that always flowed into the lake right across underneath the road and into Lake Babuzik over by Dennis Willette's cottage. And there was another stream that came in this way behind, just alongside of the Olson property, which now Rick Hadfield and Kathleen own. So the area does have some wetlands questions in it, and there are, at points, various streams that do come into the lake. Now, it's my understanding that this is going to be a residential area. Is that correct?
But they're not building any new residences, sir.
Sorry?
They're not building any new residences.
Direct questions to us.
Oh, I'm sorry. I'm sorry. So the question is it going to be residential, or is just going to be any homes or anything built on it?
The proposal does not propose any new residential units. There will be the same two homes that are there today.
Okay,
The cottage, or the camp that is existing on one of those properties is going to be demolished.
that's the Olson camp.
And then there's going to be a mudroom and garage addition to one of the two primary residences. So there will
Yeah.
remain just two residences on these two lots when all is said and done.
That's great. No, they're good people, good neighbors. And so that kind of covers my questions. It will clean up the lot. It'll definitely clean up the lot. Have you walked the lot at all? It's kind of,
I think once they get done, it'll look very, very good.
I think you're right. Thank you very much.
Thank you, Peter.
All right, while I still have the public hearing, is there anyone who would like to testify for the petitioners? Okay, I have one item here before I go any further. I believe this is an email, Tim, for these 4 cases for Kathleen, Carlisle, Richard, Christine, Hatfield, 2014-44, 2014-45, and 2014-46 from Bruce and Susan Sheridan. And I believe it came in today. It's, to whom it may concern, we are in full agreement with the cases 2014, 44, 45, and 46, proposed changes and support the town in granting the variances. And I just want to get that into the minutes. All right. Now, is there anyone else who would like to testify against these variances? All right, I'll close the public hearing.
Just to remind the board, there are 3 separate petitions that will require 3 separate motions and votes. On cases 44 and 45, there is 1 proposed condition on each of those, which would be approval of the lot line adjustment by the planning board. In the 3rd case, which is the setback case, there are 2 additional conditions. First, there's the same condition of approval of the lot line adjustment by the planning board. Second is making sure that we have a copy of the DES shoreline permit prior to the filing for the building, prior to the issuance of the building permit. And lastly, review by the Conservation Commission and satisfaction of any comments regarding that addition on the home.
Thank you, Tim. All right, could I hear a motion on the variance for case number 2014-44?
Motion to approve Hatfield, Kathleen, and Carlisle, and Richard and Christine petitioner owners variance under section 3.02 of the zoning ordinance to permit the lot size of less than 100,000 square feet for 2 lots in the R1 residential district located at 11 Autumn Lane and 46 Greenwood Road, tax map 6A-1 lots 069 and 070, case number 2014-44. Should the ZBA grant the variance, staff recommends the following: an approval of the proposed lot line adjustment by the planning board, and that's it.
Second.
All in favor, say aye.
Aye.
Anyone against? 500.
Madam Chair,
Yes, Mr. Dwyer.
permission to approve Hatfield, Kathleen, and Carlisle, and Richard Christine petitioner owners variance under section 3.02 of the zoning ordinance to permit the frontage of less than 250 feet for 2 lots in the R1 residential district located at 11 Autumn Lane and 46 Greenwood Road, tax map 6A-1 lots 069 and 070, case number 2014-45, with the following approval from staff recommendations: approval of the proposed lot line adjustment by the planning board.
Second.
All in favor, say aye.
Aye.
Anyone against? 500.
All right, going for the hat trick. Hatfield and Kathleen and Carlisle and Richard and Christie petitioner and owners, variance under section 3.02 of the zoning ordinance to permit a building addition as close as 49.4 feet from the rear property boundary where 60 feet is required in the R1 residential district located at 46 Greenwood Road, tax map 6A-1, lot 070, case number 2014-46, with the following approval of the proposed lot line adjustment by the planning board. 2, prior to issuance of a building permit for the proposed addition, a copy of the NHDES shoreline permit shall be submitted to the building department and the community development department for filing and review by the Merrimack Conservation Commission and satisfaction of any comments, and this was to approve.
Second.
All in favor, say aye.
Aye.
Anyone against? 500.
Thank you very much.
And you know the routine, right,
I get
Steve?
to go now. Oh, yes.
Yeah.
Take 5 minutes.
All right, we're going to take a 5-minute break before we get to the next item. All right, ladies and gentlemen, I'm calling the meeting back in order again. And the next item on our agenda is Robert T. Bevel, petitioner, appeal of an administrative decision seeking to overturn the Community Development Department staff decision to classify a firearms service, maintenance, transfers, and assembly businesses being eligible for a home occupation, which allowed the planning board's approval of such business located at 11 Blair Road in the R Residential and Aquifer Districts, tax map 6C, lot I-170, case 2014-42. Who is going to testify on this, please? Would you come forward? All right, would you state your name and please go into your testimony.
Good evening. My name is Robert Bevel, and I'm an abutter to the particular property of this subject matter on 11 Blair Road. I will restrict my comments to specifically the administrative decision. I'd like to turn your attention to the handout that you received from staff talking about this particular issue. In order to properly appeal this decision, there are two paths that have to be concurrently followed. The first is an appeal of the Planning Board's approval of the application to a superior court in accordance with RSA 676-15-1. That is a writ of certiorari to the Superior Court in Nashua that has already been filed. The writ of certiorari has been granted and the town has answered at this time. Secondly, and the subject of tonight's hearing, is that the petitioner could appeal the Community Development Department staff's determination that a proposed business met the definition of a home occupation and therefore was eligible for the Planning Board to consider. From the notes of that Planning Board meeting, it refers to that Chairman Best said it was important to consider the definition of a home occupation. In the past, the Planning Board has treated firearms as eligible for home occupation. Tim Thompson said that this is the reason that the issue was brought before the board, since the proposed issue has been similarly treated as a home occupation in the past per determination by prior planning and zoning administrators. Chairman Best said that the planning board could not overturn the planning and zoning administration. It goes on further down and it talks about that the planning board has considered and approved at least 4 other gunsmith type businesses dating back to 1995. In essence, the administrative decision to classify these types of businesses as eligible for a home occupation was made over 19 years ago by the town staff in place during 1995. I have obtained copies of all of these previous determinations, including the original one dated June 13th, 1995. In that packet, there was no administrative decision. The planning board voted without any kind of reference from staff or staff notes as to whether this was appropriate. Normally, for administrative staff to be able to render such a decision, there's a legal term called administrative gloss, which allows the staff, whenever there is an ambiguity or a vagueness in an ordinance, to render a determination and to present that to the board as best they can. And to me, that would be what the subject of this matter would be a document from an administrative person who says, in their opinion, there was a vagueness or an ambiguity and they were rendering this decision. That document does not exist. So to me, it would be unreasonable for the ZBA board to deny my administrative appeal because there was no administrative decision in the record of the original home occupation permit of June 13th, 1995. I also have, I'm sorry.
All right, I was just going to ask you here, there's 3 other gunsmiths that were issued permits in 2010 on Windover Lane, Briarwood Drive, and Lilac Court.
Yes.
Have you researched those?
Yes.
And what was your finding on those?
They all referred to the original one as to the zoning administration has already been taken care of and that the planning board really has no control over changing that. That would have to be done by a zoning board appeal. And it kind of disturbs me that a commercial business can be grandfathered in without a committee's oversight such as your own unless an abutter appeals it and brings it before your attention.
Tim, you don't happen to have that 1995?
No, not in front of me.
No. Okay. Does anyone have any questions or comments? Rich?
I guess, you know, my question is, you defined administrative gloss, so are you referring to that as something that the planning board used or something that the staff used?
I'm saying in order for there to be an administrative decision, the technical term is called an administrative gloss. That's what an administrative person would have had to have done. You would have some kind of document where that they said, we feel it's vague, we feel it's ambiguous, we're rendering this decision and we're presenting it to you, the planning board, to say yay or nay. That document does not exist, so it makes it very difficult for you people here to you know, grant an appeals decision if there's no such document.
So what you're saying is that there's no administrative gloss in this case. Is that what you're stating?
I'm saying, well, the administrative gloss exists because it passed the planning boards. There are 3 other that have passed since then because they're saying this document existed a long time ago and therefore we never looked, but we're going to say we're going to grandfather it in.
Okay.
I guess I'd question the word grandfathering it in. If each one was held as a separate petition, correct? Didn't they?
Yes.
Each individual go, you know, 4 different times to the planning board under 2 or 3 different administrators?
But as Mr. Tim Thompson correctly stated, those were relying on an administrative decision. Debate was cut off during the planning board whether it was appropriate for a home occupation. Again, I can't go into speaking to the specifics of that in this forum, but it has to do with an administrative decision. The planning board relied upon the fact that there was an administrative decision and stopped debate on whether a gun sales permit was a proper use of the home occupation.
He is not selling any weapons. He's repairing them. Am I correct?
He has applied for a sales permit. He has applied for a federal firearms license, which allows transfers and sales. It's not what you say, it's what you do. And he has applied for sales.
But doesn't that, he has to apply for those to be a gunsmith?
I'm not a lawyer, so I can't answer that question.
Yes.
I believe he has to apply for those to be a gunsmith.
Okay.
So that is mandatory. That wouldn't be anything out of the ordinary.
Okay.
Well, interesting discussion. I think we should try to focus the discussion purely on the appeal that's before you here tonight, whether or not the staff made the correct determination. If Mr. Bevel is finished with his initial testimony, I'll certainly await the board's opportunity for me to give the staff position on this as well.
I have other material, but only available as follow-up if reclamation needs required.
Okay. Tony, anything else?
No, that's it. I was going to say what you said, but you said it before I did, so.
No. Sorry.
It's okay.
Patrick?
Not at the moment. Just reading through the RSA and it, now I'm gonna hold for the second. I'll
All right.
hold my comments.
Rich, anything else?
I have one more.
Patrick, okay, why don't you go on, Mr. Bevel?
I have one thing,
Oh,
one big
okay.
thing. I'd like to understand the basis of why you are here. Is it strictly technical, legislative issue, or do you have an issue with the gunsmithing?
I'm not sure I can address that at this hearing. I would be glad to if that's at the discretion of the board.
I'm trying to understand what brings you here.
Okay.
What is your concern? See, if you have a concern, then we need to take a look at that concern.
Okay.
I think in this case, what we're looking at is specifically what's in front of us, just the, whether or not staff made the right determination. Am I correct on that?
Yes.
Mr. Straight, basically, one of the things that your own staff report says is that there are two avenues of an appeal for this. You don't just go for
Right.
one. One is for the administrative appeal, which comes here, and one is the appeal of the planning board decision, goes to the Superior Court. If you decide at this meeting that an administrative appeal should be granted, then the planning board suit goes away. If you vote to deny the appeal and you allow the administrative decision to stand, then it gets merged into the
Yeah, I
lawsuit.
understand all that. I was just trying to get what your concern is.
Okay. My concern is about having a gun store in a residential neighborhood.
Okay.
I don't have a problem with
That's all I need.
gunsmithing, but because he has a sales permit, because he has an FFL, he is within his right to have sales. His house will be listed on a federal license site that
Okay.
lists
That's all I
it.
need to know. I was just curious what it was.
Okay, Patrick?
You mentioned, if you allow me a little leeway.
Oh,
Madam
please.
Chairman. Thank you. In your letter, you outlined section 2.02.1, District R permitted uses, and you talk about F, which it talks about home occupations. Now, prior to that, it says home occupations except as provided in 3 below. So now if you go to, that's section 2. If you go to section 3, and I don't know, I would like to see, and I'm just gonna say that staff used these in making the determination. It says home occupations which meet all of the criteria listed below are not subject to site plan review and approval by the planning board. So these are home businesses that can exist but do not need to be approved by the planning board. Now, there are no specific no specific industries or businesses that are listed. However, if they meet the following A through G criteria, which if this individual has, then it doesn't have to be approval by the planning board on that.
If you read it that way, sir, then
Unless
that allows,
I'm gonna clarify that for
Yep,
you, Patrick.
thank you.
Thank you.
There are two types of home occupation approvals in Merrimack. The first, which is what you described, is if a home occupation can prove that they meet those set of criteria, there's no need for them to go to the planning board, and staff can approve those administratively. If they don't meet those, they then have to go to the planning board and meet the criteria under Part 2.
So if those businesses have gotten the approval based upon this criteria, I mean, that's the criteria set in place. What I think I'm trying to understand from you is that you are petitioning more of just the fact that this has been approved in your neighborhood, as opposed to just been approved in general Merrimack.
Not in tonight's appeal. That's
Okay.
the planning board appeal.
All right. I wanted to get clarification on that.
So based on prior administrative decisions and planning board decisions, is it safe to say a precedence has been set?
If the chair will allow, I'll go through how the staff came up with our determination of the eligibility in this case.
Go ahead, Tim.
Thank you. Again, looking back at previous home occupation approvals in Merrimack, we found the 4 cases that are listed in the memo below, in your memo tonight. In each of those cases, with the exception of one, they had to go to the planning board to get approval for a home occupation. Each of them was in some form or fashion, a gun or firearm-oriented home occupation application. At some point in 1995, before that was allowed to go on the planning board agenda, some sort of determination had to have been made by the planning and zoning administrator at the time to allow that to go on to an agenda. There may or may not be any written record of that official decision being made by staff at that time, but it's not uncommon in community development departments or planning departments that an applicant will be placed on an agenda based on the determination by staff that, yes, this is something that's eligible to be in front of the planning board. That is where the basis for this started, based on our determination in this particular case, was that starting in 1995, someone made a determination that these types of businesses were permitted to be considered home occupations and go to the planning board to be approved through the criteria in the ordinance for a home occupation. Further looking at this, I decided to query a couple of other communities that are nearby. So I looked at Bedford and Londonderry being 2 communities that one being a direct abutter, one being a place where I was formerly employed. In Bedford, they just recently on October 6th approved a very similar application for a home occupation for a gunsmith in a residential neighborhood, and they've approved 2 other similar applications in the past. Londonderry has at least 4 going back to 1991. Most recently one this year that resulted in a tie vote of their zoning board and no ultimate decision being made. Lastly, after the planning board meeting back in August, there was some comments made by the chairman about the process and the listings for the federal firearms licenses on the ATF website. Going through and taking a look at that cursory review of the 1,100 listed federal firearms permit licensees in the state of New Hampshire, it appears, based on the communities and the addresses that are listed on there, that a lot of them, if not most of them, are actually located within residential areas. I can't confirm that based on just the addresses without looking specifically on each individual town's zoning map, but the general sense I got was that it seemed like a good number of those 1,100 permits in New Hampshire are actually located in residential areas. In reviewing this with the town's attorney, she concurred with the planning board's determination based on the doctrine of administrative gloss. The administrative gloss doctrine, as the petitioner has mentioned, I have a quote here from the Nash Family Investment Property versus Town of Hudson, 1995, that I'd like to read into the record. The doctrine of administrative gloss is a rule of statutory construction. An administrative gloss is placed upon an ambiguous clause when those responsible for its implementation interpret the clause in a consistent manner and apply it to similar situated applicants over a period of years without legislative interference. If an administrative gloss is found to have been placed upon a cause, The municipality may not change its de facto policy in the absence of legislative action, because to do so would presumably violate the legislative intent. So based on that recommendation from our town's attorney and the fact that these have been similarly interpreted over the course of 19 years, we find that based on that doctrine, it's not possible for us to legally classify this as anything other than being eligible for consideration as a home occupation.
So just to clarify what you've just said, Tim, it's my understanding that, and again, if I'm incorrect,
Sure.
please. So we're describing a precedent that has been set in multiple municipalities, and it sounds like you also stated that breaking a precedent goes against legislature.
Based on the legal doctrine of administrative gloss, our attorney has recommended that in this case, because we've consistently applied this type of a business as being eligible for home occupation, for us to change that now would not be in spirit of the law.
Thank you for clarifying.
Any other questions? Do you have anything further to add, Mr. Bevel?
Yes, ma'am. In reference to the use of administrative gloss, I'd like to also refer to a similar case as Mr. Thompson has, and this is Enric Caller, 162 New Hampshire 314, where it says the doctrine of administrative gloss is a rule of the statutory construction. Administrative gloss is placed upon an ambiguous clause when those responsible for its implementation interpret the clause in a consistent manner and apply it to a similarly situated applicants over a period of years without legislative interference. Lack of ambiguity in a statute or ordinance, however, precludes application of the administrative gloss doctrine. In town of Milford versus Batazzi, it says the use of a term home occupation in town zoning ordinance governing residential districts is not rendered vague by the absence of a definition in its examples of a home occupation in ordinance. Anderson versus Motorsports Holdings also says the standard for determining vagueness is that generally a municipal ordinance must be framed in terms sufficiently clear, definite, and certain so that an average person after reading it will understand when one is violating its provisions. It's very clear on a reading of the home occupation that home occupations are done with tools of the trade in a home. They are not of a commercial nature. If you read the zoning ordinances of Merrimack and of Bedford and of Londonderry, none of them list any kind of occupation similar to gunsmithing or any kind of tooling or any kind of commercial nature. I have two panels that I'd like to introduce at this time.
Mr. Bevel, could you move that closer to you, to the corner of the
Certainly.
the desk there, so we can all see it?
I would like to introduce your attention to the top item. This is a typical gap bed lathe used in the gunsmithing business. The item right there is approximately 4 feet long and is not of a residential nature, it is of a commercial nature. The bottom item is a Northern Industrial metal fabrication device called a lathe milling and drilling machine. Again, it is about 3 feet by 3 feet and is used in a commercial nature, not in a home. The purpose of a home occupation is to allow people over the many years to do what they've already done in their homes. Hair cutting, babysitting, piano teaching, limited things that have to do with the tools and trades you have in your home. We specifically deny the use of small engine repairs because they're loud, they're noisy, and they become of a commercial nature. So if you choose to support this based upon an administrative decision, I also offer an alternative that this is of a commercial nature and is an improper use of the home occupation license, despite the approvals of other towns. The point being, in your own packet, it said, should the board vote to deny the administrative appeal, should the board vote to grant the administrative appeal and overturn the community development staff's determination, the planning board approval for the home occupation would be stayed, and the original applicant would be required to obtain a variance in order for the home occupation to be permitted on the lot before the planning board could approve it. That, to me, is the most logical, sensible use in this capacity.
I'm probably going to ask you something, and it's probably not in our purview, but I've got to ask it.
Yes, ma'am.
How would you know he's got that in his house?
I'm not assuming that he has that in his house. He is saying that he is doing gunsmithing, and these are the typical tools of those.
Right,
Isn't
one of
this
many.
a planning?
Just a moment. I know it's planning, but I just want to know, you don't know if that is the item he has in his house?
No, ma'am, I certainly don't.
Okay, thank you.
Would you consider occupations engineering and architecture as being something that could be a home occupation?
Yes, sir. They are already listed as professional organizations and are qualified under the home occupation list.
So with that being said, would it not be uncommon that someone in the engineering and mechanical, either whether it be hydraulic, mechanical, electrical, or in the architectural field might have equipment for prototyping and building prototypes, such as either drill presses, lathes, or any other type of equipment, whether they're prototyping either in metal or in wood? That would be part of their home occupation if they were creating prototypes for their customers that they were going to put in their car and take somewhere. So in essence, those folks as well could have equipment, maybe not as large as this, but they could have equipment in their house for prototyping, and yet that's a home occupation, correct?
With respect, I'm not qualified to answer that, but however, if I was going to make the next segue in my garage, I would probably be out of compliance as a home occupation to have those tools, because what would be necessary to make something like that would be of a commercial nature. I would have to come to this board and ask for a zoning variance because of the size and style of those types of equipment.
Well, you're talking about that specific, but I'm talking about smaller prototyping when it comes to engineering and you creating smaller, whether it be medical devices, and we can go on and on about all the specifics, and that's not what's really relevant. I guess what I'm getting at is that I understand what you're saying regarding the equipment. Could you not? I mean, could gunsmithing? I mean, yeah, it's not engineering, architecture. I mean, those are also trades that would have that type of equipment in the house. So I don't see where. I understand what you're saying about small engine repair, and I don't want to get into the specifics as far as what type of engineering or architecture is out there. But I do know that there are individuals that do have that type of equipment for prototyping, and that's part of their business, their home business. So I don't see how the equipment is really relevant unless there's, unless if it's going to be inside.
The relevancy of the equipment is that there's legal precedence that equipment of a commercial nature violates the home occupation.
Equipment
of a commercial nature violates the home occupation.
What constitutes commercial nature? Just so I understand the true definition. What constitutes commercial nature?
I'm not qualified to answer that question.
So are we discussing something that is not relevant to zoning? Because I guess my question here is, we're discussing items inside of a house where our role as a zoning board is to discuss, how many doors there should be on the house, what the square footage is. At no point in time should we be addressing or even discussing items, because they just do not fall under zoning board. None of this falls under zoning board. I mean, I completely understand what you're saying, Phil. Patrick, you're right, but none of this has to do with zoning board.
Correct.
Like, absolutely none of it.
Correct.
So none of that.
Well, you're both right, because we deal with reasonable use of a property, so. But it's too vague anyways. We need to get back to the administrative decision.
I also, in summary, have a zoning ordinance protest petition signed under RSA 676-5 by 5 of the 7 abutters that I'd like to submit into evidence.
You'd have, go ahead.
I was just going to ask the board if they want to accept it. We don't usually accept paperwork the night of the meeting.
Unless it's something that we have prior, like such as the map earlier this evening.
Okay.
We have to have time to study it, so we'd have to take an hour and a half recess or postpone this meeting.
Okay. It just demonstrate for those people who were not here their support. There is another supporter of my position in the audience tonight.
Yeah, but administrative, we're talking about administrative appeal here, not the actual fact.
So do you have anything else that you would like to present?
I'm finished, Your Honor. Thank you.
All right. Any discussion? Okay, I'm going to open the public hearing. Is there anyone here who would like to testify in favor of Mr. Anyone here who would like to testify at all? How's that? Come forward, sir.
Were you sworn in, sir?
And also, would you sign the sheet, please? Your name, sir?
My name is David Preisner. I live at 15 Blair Road.
Press the button.
You
Green
mean-
light's on.
Oh, okay.
Is it bright green?
Now it is.
Okay.
Sorry. Okay. My name is David Preisner. I live at 15 Blair Road. I am in an abutter to the application here for the, not the applicant, for the applicant who's for the home occupation. I just had one thing I wanted to give to this board as some information. After the planning board meeting, there was some information that was not disclosed during that meeting that I think is relevant, and it didn't come to my light until like 45 days after the planning board meeting. I have a letter here from the Community Development Department to the planning board, and this is dated August 13th of 2014. And this letter is a recommendation that the planning board vote to accept the application and grant final approval of the home occupation permit, okay? And it's based on several stipulations in the application for the home occupation permit. One of them, and I'll read it. The premise is served by a driveway off Blair Road of approximately 65 feet in length from the road to the house, and also has a longer driveway from Brenda Lane through an abutting lot to an outbuilding on his property where this work is to be done. I own that lot that's stipulated here, the abutting property. There is no driveway, and there's no access to that property off of Brenda Lane. So the application information that was given to the Community Development Department for their recommendation to the planning board was false and incorrect. Now, my attorney has sent a letter asking that this information be corrected to the planning board, and to my knowledge, it has never been corrected. So the basis for some of this approvals was based on information that was false.
I don't know, you look at me, that's community.
No, I can look at all of
Okay,
you. I'm
yeah,
just,
no.
no, that's, I just wanted to
The
bring
planning
this to
board's
the,
decision is not under the jurisdiction of the zoning board here tonight, and we really can't consider the decision that was made by the planning board. There's simply no jurisdiction for this board to deal with that tonight.
but where do I go with this information?
If there's a letter that was sent to community development, I have not seen it.
No, the letter wasn't sent to the community development. It was sent to the person who has the application for the permit, asking that person to correct his application to the,
There has been no action on the approval from the planning board by the applicant at this time.
so that,
There
so
has
it has
been
never been
nothing,
corrected.
we have seen nothing since the August meeting in terms of meeting the
Okay.
conditions that the planning board had put on that application.
So the false information on the application has not been corrected.
I'm not going to speculate as to what that is, and I certainly would invite you to continue that discussion with the applicant for the home occupation. And if you want to provide that information to the Community Development Department, we'll certainly look into it.
I will provide it then. That's all.
Is there anyone else here who would like to testify either in favor or against the appeal? Have you been sworn in, ma'am?
Raise your right hand. Swear to tell the truth, the whole truth, so help you God.
I do.
And would you sign in on the sheet and state your name, please?
Yes, ma'am. My name is Carol Babel. I'm in a butter at 6 Brenda Lane in Merrimack. I've lived in this community for 9.5 years. And it's interesting to me to listen to the conversation this evening while the zoning board is here to enforce and make decisions on policy procedures, rules, regulations. I think that something that we need to use is common sense, since the precedence has been set based on nothing, no documentation that anybody can seem to locate. That the product of the home business, if that product can harm the public, and certainly guns can harm. There's been, so much in the news media about people's lives being taken by guns. And I'd like to share with you, as a former special education teacher of teenagers who were taken away from their families and made wards of the state when I was a teacher in the state of Connecticut. A lot of these kids had gotten their hands on guns and committed crimes, and they were thrown out of public school. They were stripped from their parents. And if I didn't turn them around as a ward of the state, they went on and they did hard time in prison. We already have several gunsmithing types of businesses here in our community. How many more will you pass? I bought a home here almost 10 years ago to get away from a bigger city area with a higher crime rate. And I'm not comfortable having multiple gunsmithing businesses in my community. I grew up with guns. I hunt with my father. So I'm not opposed to the, having guns for self-protection and hunting. But that, as a private citizen, is a big step from having a gunsmithing business and selling guns, and having these types of businesses close to our schools where children can gain access to them. So I implore you, as our elected officials, to give that thought to what the product is when you're reviewing petitions. Will it increase and benefit the greater good of our community, or could it possibly harm our citizens? That's all I wanted to share with you this evening.
All right, thank you very much.
You're welcome.
Anyone else that would like to testify? Would you step forward, sir? And have you been sworn in? And would you sign in, please, and state your name?
My name's Michael Mailer. I'm the one that they're complaining about. Basically, I came, back in August, and I stated what I was planning on doing. Me repairing and cleaning guns and such. Absolutely no ammo. There's not going to be it's all no walk-in service, all by appointment. I'm trying to do this as friendly as I can, with the concern of the neighbors, that they're not, being put in any harm's way at all. Whether I'm working on a gun or working on a golf club, if there's nothing to go with it, to me, it's not a danger to anybody in the environment. And that's what I'd like to just say is that, I appreciated, being able to have the opportunity to go into the small arms business. And you are correct, there are certain things to get the FFL and the local law licenses that need to be taken so I can be a gunsmith. And that's why I want to be as a gunsmith. I don't want to be a salesman. I'm not going to have racks and all that happy stuff with a whole bunch of guns for sale. I basically want to be the guy in the back that's maintaining them. And that's pretty much what I do for a living. And, I think that's kind of my side of things.
May I ask a few questions?
Certainly.
So the licenses that were stated here that you've acquired or you're obtaining, you need to have those licenses to be able to be a gunsmith?
To be a gunsmith, I had to get through the ATF, I had to get FFLs as a manufacturer and as a importer. Those are the two minimums that you need to be able to be a gunsmith. And then for me to obtain those, I had to go to the town, and the chief of police and the town management had to give me a license for pistols and revolvers, which they did in fact do. I have all, the proper paperwork that I've been doing this the right way throughout the whole process. I went to the ATF. I went to school to do this, as a part-time thing, and that's all it is, a part-time thing. A couple hours a night and a little bit on the weekend. That's it. No walk-in service. No advertising. I'm not going to be putting signs or anything up. It's going to be, a limited clientele. Basically, my friends and my family is all I'm going to do it for. If I don't feel comfortable with somebody, I'm not going to turn around and try to repair something if I don't trust them. That's just not me.
Yeah, you're saying it's mostly a hobby. My question to you is, people that are concerned about a hazard, people bring you broken, non-working guns, and you fix them, correct? Typically non-working, or do you do surface work?
I'm looking more to be a maintenance, when people want their guns cleaned and adjusted or scopes put on or whatever that they're not comfortable with doing, that they'd like to have a professional, take it apart and clean it properly, not just throw a couple of swabs down the barrel.
Okay.
And absolutely no ammunition unless a piece of ammo happens to be jammed in the gun, which I would have to, obviously transport to a safe environment. Right now, I'm in the process of going into the Londonderry Fish and Game Club so I can use their ranges to, set up, scopes and sights and all that stuff, because there's not going to be any ammo, no gunfire at my home.
Which, in case anybody doesn't know, that was part of the planning board condition, no ammunition.
Yep, and that's not going to happen.
So you want to open a gunsmith shop as opposed to a gun selling store?
Yes, I want to be the guy in the back that works on the things, not selling them. I'm not a salesman by any stretch of the imagination.
Patrick?
No comments, Madam Chair.
Okay. Tony?
Once you repair or clean the weapon, do you have a safe that you put the gun in and lock it up?
That was one of the conditions prior to me opening, is that I had to get a lockable safe to protect the the person's arms before they go back while they're in my care.
Thank you.
We're talking walkable, we're saying a metal
safe.
container
Yes.
as opposed to a wooden glass one that you can see
No.
the
No,
the weapons in.
a real safe.
There was quite a bit of specific discussion on the difference between a gun cabinet and a gun safe. Mr. Maliar had originally proposed a gun cabinet. The planning board requires a gun safe.
Oh, just for your information, if you didn't see it, planning board gave him quite a working over. Back to the decision. But that's really neither here nor there. We're trying to deal with the administrative. Did the administration make the right call or the wrong call? Did they make the right decision with what they had to work with? That's really all we're concerned with.
All right, do you have anything further, sir?
No,
All right, thank you.
thank you very much.
All right, would anyone else like to testify? And Mr. Bevel?
Thank you. As a follow-up to this, this is not anything against Mr. Maliar or his family or anything that he's proposing to do. This is strictly for the administrative decision that was made at the time. My problem with that was that at the planning board, the way the home or occupation reads, that it's the responsibility of the planning board to decide the criteria for determining whether a home occupation is proper. That process was intercepted, saying that there was an administrative decision previously. After researching that, I have found there is no administrative decision. So therefore, I'm appealing for this board to approve my appeal because there is no decision to rest upon for that decision. Again, this is nothing against Mr. Maliar. It's against the process that just kind of grew out of control. Thank you.
Tim, do you have anything?
Just lastly, that, again, the two options that are there for the board are to grant the appeal and overturn our decision. If that does happen, the home occupation would be stayed. The original applicant would then have to obtain a variance in order for home occupation for that particular type of business to be located on the site, and it would also stay the Superior Court case. Should you deny the appeal and uphold our decision, the decision for the home that the planning board made would be considered valid. The petitioner's appeal in Superior Court would continue. And as well, the applicant would also, as is per any application before you, would have the opportunity to request rehearing, and failing a rehearing, would have the ability to appeal the decision based on this interpretation of the ordinance to Superior Court as well, should that be the way that this goes.
Okay, last call. All right, I'm going to close. Do you?
So, again, just to clarify, so what you're saying is that if we vote to approve the appeal,
And
then
overturn, you'd be overturning
and
this.
overturn, then essentially what we're doing is we are overturning a planning board.
You're overturning a staff decision to classify this as being eligible to be considered by the planning board. And in such, the planning board's decision would then be stayed because it would no longer be eligible as a home occupation, which would mean that that would have to go through another process in order to move forward.
Okay, thank you.
All right, I'm going to, any other comments from the public?
Final one, again, in my opinion, it would be unreasonable to rule against it because there is no administrative decision to rest upon. Thank you.
All right, I'm closing the public hearing at this time. Okay, last round for the board. Patrick?
I'm good, Madam Chair.
Thank you. Tony?
I'm good.
Phil? Rich? Okay, do I have a motion?
Okay, in the issue of Robert DeBell, with asking an appeal for administrative decision seeking to overturn the Community Development Department staff decision. Case number 2014-42. I move that we deny the appeal. I think the appeal was in good faith. You made the best, staff made the best decision that they could possibly make, and a reasonable decision. And of course, as stated, they can take this on to Superior Court and try to get a ruling there. But to say the staff made a mistake, to me, they did not.
All right, do I hear a second?
Second.
All right, all in favor to deny the appeal, say aye.
Aye.
Aye. All against the 4-1-0. Mr. Bevel, your appeal has been denied.
Would like to ask a question, staff. And as much as this has been going on 19 years now, has there any discussion to get gunsmithing on the zoning ordinance or off? Are you going to?
That would be a totally appropriate topic to bring up at your joint meeting with the planning board in December.
Well, you're planning and zoning.
Absolutely. That's a policy decision that, as staff, I would need direction from the planning board before moving forward with something like that. So if this is something that the zoning board feels should be examined as an ordinance amendment, that's certainly something that we can discuss at that joint meeting with the planning board on the 2nd.
You're saying you won't do it?
I can certainly bring, if it's the will of the board here to have me bring it to the planning board in advance of the meeting in December, I can do that, but no action would be taken because of the process it takes to do a zoning amendment.
Oh, of course.
So
it takes forever.
There's one planning board meeting in November, which is going to have a relatively full agenda. So December 2nd would be the next meeting after that, which you all will be at. So I think that's probably the best
That'll be
avenue.
under my announcements, but why don't we take a 5-minute break here? A 5-minute recess. All right, I'm reconvening the Zoning Board of Adjustment meeting of October 29th, 2014. And I would like to...
Discussion of other items.
Right, thank you. I asked Donna to put this on the reminder for me so I wouldn't forget. The chairman of the planning board, Bob Best, and I have set up a meeting between the planning board and the zoning board for December 2nd. And I'm not sure if it's 7 or 7:30 yet. 7:30. And if you have any topics at all for this joint meeting, I'd like you to send them to me or send them to community development. And if you send them to me, I'll pass them on to community development. Any topics, questions, comments, anything that comes to mind that you'd like to discuss with the planning board. So please mark your calendar for December 2nd, because I'd love to see the whole board there.
So that's a Tuesday.
Yes.
Are we?
Yes.
On another topic, next meeting. Is November's meeting on the 19th?
Yes.
Okay. Thank you.
Tim, do you have anything to add to that joint meeting?
I am all set tonight.
Okay, if everyone's all set on,
Well, actually, there's one thing I wanted to bring up, and I promise this won't be like before where we spend 45 minutes just kind of talking about nothing here. So we did discuss a couple of times now the possibility of changing the preamble to include You know, I know, Patrick, you love pagers. And
Useful technology.
absolutely. So I was thinking of putting together just kind of like a draft that, and I would like to be able to send it to the planning office to have it emailed out to all of you so that we can, you know, read it over the next month.
I thought we had discussed that before, and we told you to go ahead with that.
We did. This time I actually mean it.
What is this again? I lost it.
That was discussed at the last training session with the non-meeting with legal counsel.
Well, a few things were brought up, and I just want to make sure I'm clear that there were a couple things that we wanted to start considering adding to the preamble.
Updating
Why,
it.
why do you want to, would you change the Declaration of Independence?
Yeah, I would.
Why would, oh, okay, well.
It's a modernization of the preamble.
An upgrade?
Getting
Oh,
rid of
yes.
Like the
You're
iPhone
gonna
6?
change the
We're
preamble.
going to have a preamble 1.7a. It's still in beta.
You're gonna change the preamble of what it says.
He's going to upgrade it. yeah.
Just change some of the wording so it sounds like it was written, you know, in the last couple decades.
The verbiage, some of the verbiage is old.
And unneeded.
Yeah, it's lengthy, but there were some things that we were talking about adding to it, and I was trying to get input on that because
I'd certainly invite Rich to go ahead and do that, send it to us, we'll take a look at it as staff, and then we'll send comment out to the board for.
I have a question.
yes.
Go ahead.
In the preamble, since we're talking about this, can you put wording in there that material that is, something about not, that we already got the material, don't give
If
us
it's
more
not
new material?
pertinent, if it's new material, we don't accept it.
Can you
Well, one
put
of the things that we discussed, and I actually this was one of the things I wanted to bring up, is that the possibility of accepting material and then postponing the meeting. So we can, the possibility of being able to say, you can present new material, we will postpone this to the next meeting.
Well, I thought that we had asked Tim and Jillian, if I remember correctly. Donna? I would have gotten to her. She was the next one down the line. On the application itself, which now we have included in each packet, the original application.
And everybody reads it and follows it to the T. So I'm not trying to go against that by any means. I'm just
This
some
one
people
here,
need a reminder.
This one here, if you've got enough room on the bottom to put down the acceptance of materials at the last minute and put it right on the application.
So what you're saying is that instead of going the route of the preamble,
I think it would be okay to do both. Well, we can certainly add something to the application that states, please ensure that you've included all materials you want presented to the zoning board at the meeting, at the date of your hearing. The zoning board will likely not consider any new information at the hearing itself, and doing so may, require a postponement of your petition to the following month. Something
Sounds
of that
good. Write
nature.
that down and keep it.
Done.
well, that's what I was asking.
Yeah,
Do
and
you like
because
that?
I think
Well,
it's gonna
there's
make
that.
more on the application, because it should be in nice bold letters, Tim.
No matter how big you make those letters, we'll still have to remind them.
Yeah,
But I don't
I
think.
still
we'll-
think it makes sense to include it in the preamble as well.
Okay.
All right,
that's
Go
why I
right
always
ahead.
wanted.
so did you write that down?
Oh, I actually started working on it.
Yes, Lenny?
Yeah, I know we say we don't take new information at the meeting, but getting that plan from Steve tonight, I thought I had a good handle on what was going on with those lots. And I did, but seeing it in red really finished.
But that was the same
puzzle,
map
okay?
that we had already had in our packet.
Exactly. That
It
was
just
not new
outlined.
information. That
So
was
that's appropriate, that type of a situation is appropriate.
But when we're
and helpful.
talking new stuff that we've never seen before, especially if it's lengthy
Pictures.
written letters or something in writing that, we have to sit down and read.
The only part,
Yeah.
the only part of that we can't control is when abutters or other interested citizens, after they receive notice, submit information, which, as you know, sometimes doesn't come to us until the night of the meeting.
well, we can't
Those things-
postpone a petitioner because
Because of
the
an
butter.
abutter,
Yeah.
exactly.
We can't or we can?
We can't postpone the petition, the petitioner, because an abutter decides they
Correct.
want to give us handouts.
Yeah, we don't have any control over the abutters.
That's essentially part of their testimony at the meeting itself, so it's,
Yeah, I was,
it's a big clarification between the petitioner and those that are not the petitioners in terms of who can submit and when.
okay.
And you have your copy of the preamble. You want another one?
I want a different one.
Do you want this one as a worksheet?
Oh, I already have one. I actually started it on my computer. I didn't bring it with me because I wanted to talk about it.
No, please go ahead with it.
Okay, thank you.
Okay, is there anything else in discussion? Any more discussions on anything? I want to keep Tim here.
Motion to approve minutes September 17th, 2014.
Not yet. Now, motion to amend,
Motion to approve minutes September 17th, 2014. As submitted.
Do I hear?
Second.
That's a second.
Any corrections, misspellings, punctuations? Lenny?
I was not seated this evening, I understand. I was seated for item number 3 of those minutes. I concur with that, and you can take your vote on the full context.
I'd also like to note that on line 40 of page 5 of 7, it says that I seconded the motion, and I just wanted to concur that I in fact did second the motion.
All in favor?
I haven't, congratulations, Sam.
What the hell was that all about?
All in favor, say aye.
Aye.
But now I want to bring something up. Do I hear a motion to, Tony?
Tony?
What?
Adjourn?
Who's it, what journey?
Oh, okay,
I'll
we'll
make a
just stay
motion
here.
to adjourn.
Second.
Accepted.
Commitments or anything like that at this point, so.
I'd like to sit down and
Okay.
talk to him.
Does anyone else want to be part of that initial conversation?
Sure. I know Chris, so.
You do? Yeah?
Yeah, well, we work together, so we did.
All right. Great. All right. So, mind if I just forward email addresses and put that, throw it out there? You want me to use your town
Sure.
email?
Yeah.
Okay. Do you want your
Yeah,
other email?
I'd love to be.
I'm gonna try to. I've been checking my town email more. I've been very good about it this month, so keep going with it.
Listening to you. Being up the hill. Okay. If we go beyond 3 people in the commission, we're starting to look at, you know.
Well, you just send out notice, and if people can go, great. If not,
Yeah.
we can keep it at bay easily.
So you want to be part of it?
Yeah,
too?
I'd like to.
Okay. Great.
It's interesting, so whether I can do anything with it, I don't know.
I think it's a good option for us.
Yes. Yeah. Kind of nice that Simon and whatever kind of made that contact. So I appreciated that. So